On behalf of Amnesty International, one of the largest human rights organizations and associations of citizens globally, I bring you greetings and good morning. As the sun sets on the first decade of the Kenyan Constitution, last year is probably going to be remembered as being a year of tremendous promise, but also a year of tremendous risk from the perspective of building a digital democracy. We went from a situation where probably the government had between 5 to 10 points of data on every citizen to at least 70 to 100 points of data by the end of the year. To make it very simple, the government of Kenya got very personal with us last year. We saw 2 substantive amendments, a draft policy, 3 bills, substantive bills, all of which, I guess, tried to reframe the registration of our identity, our very identity as citizens, that began to frame, once again, mass surveillance technology and the use of CCTV cameras, and also began to sharpen a tightened control over our activities online. But I think at the same time, there was not just the risk that came without all of these interventions, these invasive interventions, without a Data Protection Act. What we found towards the end of the year with the passing of the Data Protection Act, which was supported very much by a number of the human rights organizations and is an important breakthrough, not just for the country, but for the continent and other parts of the world where there are no safeguards on data. What we've begun to see is the opportunity for a responsible use of data for development. So for those of us who are very concerned about Chapter 4, the Bill of Rights, it now gives us the capacity to be able to demand closer accountability of government services in terms of how they impact on marginalized and, marginalized communities across the country. So I think we need to look at data from 2 perspectives. One is, yes, how do we protect the right to privacy and informed and prior consent over the use of our data? But the other issue is actually how do you use this tremendous resource that is now available to government for the development that we so want to hear, so want to see. And for those of you who have studied the census, one of the things that struck me in the Kenyan census just recently released was how much of us are now on the internet, how much of us have access to smartphones, and what does that give us as potentially power to be able to bring 47.5 million Kenyans into a digital democracy. Because the one thing that we've learned from last year is that an analog democracy, even under our progressive constitution, will not sustain a digital invasive strategy on behalf of either the state or commercial actors. So I'd like to end really by just encouraging those of us here, whether you are digital activists, whether you are legal activists, to essentially frame our work going forward in the next couple of years around 3 concepts. The first is the right to privacy. The second is the right and the obligation of citizens to involve and to participate democratically in the building of our nation. And the third one is the exercise of legitimate and lawful dissent when the use of state power is either contrary or is contrary to the provisions of the Constitution, and in particular, the Bill of Rights. So these 3 things, the right to privacy, democratic participation, and legitimate dissent, really are at the frontier of this conference. As the International Commission of Jurists have done, we also, as Amnesty, associate ourselves with this initiative. We congratulate Lawyers Hub and all the organizations that have gone to this, and we wish you all a wonderful day and a informative and educative conference. Thank you very much.